Have you checked that? Because people just talk about them like they're synonymous. A conspiracy and common purpose. And also it can include prior planning. You don't, these two concepts, you're saying they're synonymous. So
you mean they're the same?
You use inferential reasoning anyway, you have to, because it must come to the knowledge of the participants who are less than two. I mean,
so, my lord.
At the most, they are 2 plus. They plan allegedly. And that knowledge of the planning, they are bound by it, because as it is said that they want to execute a particular project. And if they don't divorce themselves from that project, are they not bound? It's because Mr. Omalo was using Ngedezi. Ngedezi, is it not narrow? If you use the other cases, I'll come with them. If you use other cases concerning
common papers.
Yeah, common papers and conspiracy. You can be involved in a conspiracy and not be present at the scene. And you can also be involved in a, no, it's the other way. You can be involved in a common purpose and not be at the scene. Is that not so?
That is so, my lord.
Sometimes you can be involved in a conspiracy and also not be in a scene.
In the scene, that's correct.
So when you say if a person is not at the scene and yet is involved in a conspiracy, are you excluding him even for conspiratorial purposes, or how do you reason it?
I think it's the manner in which we use the words interchangeably.
Interchangeably, okay,
yes.
fine. I hear you.
In paragraph 32,
okay.
It is submitted that the application for discharge ought to be dismissed. And that is the end of our apologies, my lord. As Captain, my lord, just been reminded also to just place one aspect before I pose regarding the first appearance of this matter at Boksburg Magistrate Court. That is on Exhibit EE, that is before court now. Accused 3, and I'm not quoting him verbatim, my lord. He says that when this incident of the 26th of October happened, he was, or they were incarcerated, which is in direct conflict with what we have seen in this matter. The Exhibit S, what Ms. Pinkifa Ifilingam has told the court, what he has said through his lawyers, Mr. uMnisi, as well as Mr. Ngomalo, that they were enjoying this joyride in Ekumbi with Sigayo, Falka, Pelimpilon and others. He was not in custody. He was outside when the deceased was shot and killed. That was his first.
Where do you get that evidence?
Exhibit EE, my lord.
EE, what does EE say?
It's a transcribed record of the first appearance at
Yeah. Who was making that declaration?
Accused number 3.
Through his attorney? Sorry,
himself, personally.
Hello?
He made it directly to the court.
Oh, personally?
That's correct.
He tells the court, when this thing happened, I wasn't around Joburg.
I was incarcerated.
Oh, Gauteng, I was incarcerated.
That's correct. The record is there.
It's recorded.
Itself, my lord. We have the transcribed record is before.
No, fine. No, I just want to know if it is. Then I'll check it.
That's correct.
And Mr. Ngumalo, what does he say?
No, it can't be checked.
Hello?
It can't be checked later. It must be checked now.
No, you don't know about that.
No. I've never heard.
If you don't know about that,
no, it's news to me.
Okay, it's news.
May I also make a follow-up, my lord, because it affects my client very directly. The court will note that this is not a time to introduce new evidence.
It's not new evidence, Mr. Nis. If it's recorded,
I am not saying that
if
this
it's
is
recorded
new evidence.
before Mr. Ngumalo started addressing this court, it can't be new evidence.
My lord, I am saying,
Yeah.
and if the court can hear me, and please hear me well, please. I'm saying this is not a time to introduce new evidence. And that information that Advocate Sibanda says before he sits down, he wants to introduce it, should have been information, had it been brought to our attention. If that was the state's case, all along, before they closed their case, definitely that information would have been a subject of a trial within a trial to determine the circumstances under which accused number 3 allegedly said all those, whatever it is alleged that he said it. But now that he says it now, my lord, now that it is said that he said it then, but that information is being introduced now.
No. You're talking at process purposes. According to your colleague here,
Yes.
the doctor, he says this was said at the first hearing.
I'm
Like-
going to
it's
request.
like a plea. It's like a plea.
Yes.
First day you plead guilty or not guilty, and you say not guilty.
No, it can't be like a plea, my lord, because there's a specific format that prerequisites that lead to a plea. In other words, precursors to a plea. They explain your rights to legal representation. You make a decision whether you're going to conduct your own defense, whether you're going to be assisted by legal aid, or whether you will have your own attorney, and the implications of you saying something. That must be explained to you. So we don't know if those circumstances before accused person actually uttered what it is alleged that he uttered, those circumstances were explained to him, which is the reason why I say, if the state wants to rely on that information, it should have been something that was brought to the attention of accused number 3 in conjunction with me, so that we map a way forward as to the admissibility of that information. But as is now, that information is totally inadmissible. Unless it should have been a subject of a trial within a trial, my lord.
Let's hear, Doctor, what are you saying? You say you can't use that information.
I'm accused number 3, my lord.
Yeah.
A request to see me.
Okay.
I'll wait for Mr.
Yeah. Hello?
I'll wait for my colleagues.
Okay. Have you read of a case called State versus ngenkathi, 1949? Anything, that decision says basically, anything which says by counsel or his word in court, it's recorded.
That is correct.
Everything. 1949, so I was 2 years old.
I was 5 years old.
Yeah. Yeah, okay, let's hear. Yeah.
I'm instructed by my client that he would want the record of the 26th of October. Sorry, not 26th. Of the 27th October 2020 when they appeared in Boxbed, because to him it's news. It's
Yeah,
news. I've also never heard about that. Thank you.
Is it please the court?
We've got it, that record. Remember there was a dispute about what the magistrate should have said and didn't say. And then somebody brought the typed record. Is that not so? Of the 7th of July. 27th July, sorry. Yeah, you're right. Okay, fine. So you want to see the record? They say they want to see the records.
The charge sheet.
The record?
The charge sheet of, reflecting the date of the 27th of October
Okay.
2020.
Yeah,
I
fine.
thought,
This is mine. No, this is.
I thought Mr. Ramosipil will bail me out as an attorney because this information, when we introduce information, it pertained to his client. And it was discovered during trial within the trial when we were dealing with the issue of. But when we introduce a document, we do not say this document only binds this one. It's a document before court. You can use it anyway, anyhow you want. The document was disclosed. Mr. Ramosipil can bail me out. I trust him to do that. He knows.
He knows.
Yes.
No, but it doesn't answer to our concerns. Still.
We cannot just disclose a document, my lord, to Mr. Ramosipil. We disclose to all of them.
Okay, fine. So,
But if they want the document to be disclosed, I can email it to them now, or we can print copies.
Yes. Print the entire.
But for now, my lord, I'm going to read what accused number 3, said.
yeah, okay, fine.
But before I do that, because I know this court wants authority,
Yes.
so I'll start with the authority.
Yeah, fine.
Section 235, subsection 1 of the Criminal Procedure Act, proof of judicial proceedings.
Is it please the court, my lord? That is exactly what I said. This is an application for section 174. This is not a time of leading evidence. And this application is got to do with accused number 4. If the state wants to reopen their case, they are welcome to make an application and say, having traversed the application in terms of section 174, there is this other information that we also want to introduce that relates to accused number 3. May we kindly reopen our case? But things cannot be done haphazardly the way in which it is suggested that they should be done here, my lord.
I haven't heard what Dr. Sibanda, I don't know what he wants to say.
No, he says exactly what I'm
let him
explaining to the court, my lord. He wants to introduce this new evidence.
Let him say what he wants to say. I don't know what he wants to say. What do you want to say, sir?
My lord, I was just making my last submission to say this is what accused number 3 said during the first appearance, and then there was this.
And then you said that you wanted to quote something.
I wanted to quote to say, but this evidence already is before court, and then it was brought in terms of this section.
Yeah, so
judicial
let's
proceedings.
tell us, educate us about that section.
Section 235, subsection 1 says, it shall, at the criminal proceedings, be sufficient to prove that original record of judicial proceedings, if a copy of such record certified or purporting to be certified by the registrar or clerk of the court or other officer having the custody of the record of such judicial proceedings or by deputy of such registrar, clerk or other officer, or in the case where judicial proceedings are taken down in shorthand or by mechanical means by the person who transcribes such record proceedings as a true copy of such record is produced in evidence as such criminal proceedings, and such copy shall be prima facie proof that any matter purporting to be recorded thereon was correctly recorded.
Okay.
That's it.
And so what was recorded according to you?
And I want to place on record what was recorded. And I'm just placing that relevant passage. Accused number 3. Okay, I'll start with the court. No response from accused 1. Accused 3, Mr. Mngube, do you wish to respond to the explanation about legal representation? Your Worship, accused 3, Your Worship, I do not see the necessity of having a legal representative because I do not know why I was brought before court. I will not enter the accused dock, Your Worship, because I did not feel, then there was no recording. Your Worship, the police officers, they were with other people. They came to us. It is alleged that at the time of the incident that we were outside, and it was later discovered that we were actually incarcerated. On actually what had happened, and that again, Your Worship, and decide as to what happened, and again, Your Worship, our constitutional rights had not been taken into consideration in that regard. So even at this time, Your Worship, they are not taking our constitutional rights into consideration, and that we, the people who actually committed that offense, they were outside, and that time we were incarcerated.
Okay.
And the date of this was 27 October 2020, and what I was reading is on page 4 and 5.
Yeah, fine.
Then I will pause here, my lord.
Okay. So what do
I will now
we do?
hand over to Advocate Baloyi, my lords.
Yeah.
Yeah, go please.
I thought Mr. Ngumalo wants to respond. You said you wanted to respond to the Makalani. Yeah.
The interpretation first.
Oh, the interpretation first. Okay, fine. What's the time now?
I don't think this whole... The state took the whole day. I don't think I can do it in 30 minutes, my lord, please.
Oh, so you suggest we do it tomorrow morning?
Tomorrow I'm in Joburg High Court.
Well, somebody's coming here, is it not?
I would like somebody to come, but he asked me to assist him because he struggled yesterday with this document.
Oh, is that so?
Yes, that's fine.
So, Joburg, are you presiding there also?
Yes, my lord, it's a recruitment. We are pressed for recruitment.
Is it?
We're even working this past weekend, Saturday and Sunday.
So, that
So
gentleman
the principal is on sick leave. They asked me to come and stand in for him in shortlisting. But on Thursday, I'll
I
be...
make this submission. It is very unfair for the interpretation not to be done from the morning when the submissions were made. And reference have been made with our clients. They don't even understand what has been said about them. And then now the matter is going to be adjourned when they have not been following the proceedings.
I thought he said he will read the 2 documents. That's what I thought you said. Yeah, well,
No, I was just saying, in fact, confirming what my colleague is saying, because I could hear them saying, meaning that they don't understand what is going on.
It is true, my lord, it was said. I think there was an agreement that Mr. Ngumalo the state should go, and then at the end, I agree that was. But if they want to do it, I can go. I was only saying the time. But if it's a concern, I can then do the 30-something pages now.
yeah, fine, please do that.
Okay.
And you must read everything on those pages. I need to understand like it's
It's in English.
Yeah, and then you interpret it into English. Okay. So which document are you reading now?
It's the reply from the state, my lord.
The reply from the state.
I don't know whether Mr. Ngumalo's one was done yesterday. I don't know.
It was done. Yeah, yesterday there was a,
No, it's fine. It was understood.
it was done. So interpret the heads of argument of
By the state.
the states.
Seven, page 4.
Okay.
Page 4. The judge is still on page 4.
You know, to be fair, let's do it the other way around. When you read it, let's start by saying state submissions, re-application for section 174, Act 51 of 77, discharge, application by Mtotogis Emapisi, accused number 4. Lena impendulo is this one. Then you do it in Zulu. So you read English, thereafter you read Zulu, so that nobody can say, Awuzwanga or Atakazwanga in. Okay, let's do it that way. We interpret it same time. You read it in English, you interpret it same time, just like that, until we finish that document. Okay. I see you're smiling, Mr. Are you?
No, don't say that. No, I was having a concern, my note, that it was done in English. It went through in the English version by my colleague, Dr. Sibanda. So you can just interpret.
No. Let him do it the way we should do it. You read the English heads, and then you interpret them into Zulu. Fortunately, every gentleman here is Zulu speaking, so it don't be so to this Zulu. Yes, sir, you may start.
I've never done it the way the court says I must do it, my lord. The court is making it difficult. I've never done it that way, my lord.
What's the difference?
It's already in English, I must just do it in isiZulu, my lord.
No, just do it the way we suggest you do it. Because they won't know what I'm interpreting. Because these gentlemen, they can hear English. And I repeat, I once had a gentleman telling me that he certifies document in Rustenburg. He takes that document for certification. And I told him there are very few judges who can express themselves like you. So so read it for them in English and then interpret it in Zulu. And that's how we should do it.